says, but what the courts have said over the years, what the executive arm of government, the land offices have been doing over the years to impede valid title to land, and in effect, the problem of shortage of houses. Let's take one example. The Land Use Act provides or empowers the governor to revoke rights of occupancy. It sets out the conditions for certain revoking right of occupancy. One of them is that notice should be served, and once notice is served and the conditions are met, then the title of the right holder terminates. When the matter came before the Supreme Court in 1990, Justice Obaseki said it was not enough to give notice to the right holder. Government should also comply with what was then Section 33 of the Constitution, which is now Section 36 of the Constitution, namely fair hearing. A person's property rights are being taken away, and so government should serve him notice of why his right is to be revoked, and so on, right of fair hearing. That is not set out in the Act. The courts impose that. Now we feel that is good enough because it secures the title of the right holder. We take another example. Section 38 of the Section 8 of the Land Use Act provides that when the governor is granting right of occupancy under his hand in Section 5, he should determine the term. Practice, each time a right holder applies to the governor for a certificate of occupancy, the governor seizes the opportunity to impose terms, one of which is maybe 30 years in some parts of the country, 50 years, 70 years, in most cases 99 years. Now for those who think that 99 years is forever, we'll take our mind back to what happened in Delta State recently. When the white men came, colonial masters came early 20th century, leases were granted to them by people in the Niger Delta area, Seple Warri area. The lease was for 99 years. The lease expired about 10 years ago. Now the local people went to court to assert title to the land and the improvements thereon on account that the 99 years lease had expired. And the High Court simply said, yes, the lease had expired, the land reverted to the owners. Many of the houses on those lands are owned by government. Hospitals, general hospitals, and so on. Now, government is campaigning to ensure that the local people do not demolish those houses and take possession of the land and grant leases and so on. So 99 years is not forever. So that is part of the problem we have with the Act. Another problem we have with the Act is that many persons have the misconception that government owns all lands in the state. Indeed, as late as 2006, 8 years ago, Professor Fabumi, who teaches equity in Ife, Obafemi Awolowo University, said that with the enactment of the Land Use Act, sale of land is prohibited. This misconception has led many to backdate documents of transfer to 1977 or the first 2 months of 1978 with a view to ensuring that they are not selling land which belongs to government. Now the Land Use Act does not say that all lands now belong to the government or to the government. The Land Use Act provides that lands are vested in the governor. Now the word vesting, or it is common among lawyers that when we are interpreting statutes, we don't look at one section of the statute. we don't look at even definition section. We look at the entire act to ascertain what one section says. Now, when section 1 says land is vested in the governor, when we look at section 48 of the act provides that all laws relating to transfer of land continue to be extant, in effect, subject to the provisions of the Land Use Act. So, registration of instruments, transfer of land, and so on, are all extant, subject to obtaining governor's consent. Obtaining governor's consent does not mean that you have to go and get his consent before you transact, before you negotiate, and so on. Because of this, in one case, Omoni and Alabi, in 2004, land was sold, or a house was sold in 1993. Sadly, the lawyer backdated the instrument to 1977. When dispute arose, the issue turned on whether the transfer was valid. And Justice Okumola of the Court of Appeal heard that the transfer was fraudulent, it was deceptive, and it was void, because it was backdated in 1977, intended to circumvent the provisions of the Land Use Act. So what we're saying in essence is, even with the Land Use Act, land can still be transferred for the purpose of housing and all other purposes, so long as the consent of the authorities is obtained. In 1990, Justice Belgore said that the Land Use Act is not a magic wand it is being portrayed to be. It is not a destructive monster that at once swallowed all rights in land. In essence, the Supreme Court recognized that rights to land, customary rights, and other rights remain subject to what the Land Use Act says. The Land Use Act does not prohibit and terminate all interest in land. So land rights are still there for use. With regard to housing needs, in many parts of the world, housing needs are met at local government level, not federal, not state. There's a principle of federalism they call subsidiarity, which means what touches the common people most should be handled by the lowest level of government. Housing touches people, and so as much as possible it should be handled at local government. The Land Use Act provides for two layers of governments to handle land rights: local government and state government. Section 2 of the Act provides that local governments should handle matters relating to customary rights of occupancy. The state government handles statutory rights of occupancy. Section 3 empowers the government, the state governor, to declare certain parts of the state as urban and certain other parts as non-urban. In this regard, the governor is given very wide powers. But it is intended, I believe, by the lawmakers that rural parts of the state should be declared non-urban, and cities and large towns should be declared urban. Remarkably, in Lagos State in 1980, the governor of Lagos State, Jakonde, declared all parts of Lagos as urban, and it has been so ever since. So that when it comes to land rights and land management, local governments in Lagos have no say, because all parts of the state are declared urban. The same applies to the Federal Capital Territory. No minister of the Federal Capital Territory has declared certain parts of the Federal Capital as urban and non-urban in accord with the provisions of the Land Use Act. So, when the issue arose in a case called Ona and Atenda in 2000, The land in that case was granted by local authorities, local authority, and the issue turned on whether it was a proper grant. And the Court of Appeal held that the grant was void, invalid, because no local authority has authority to grant land rights in FCT. Which means that even where the local government is inclined to develop housing for the purpose of maybe the low income persons and the poor and so on, the local government has to go to the central government, in Lagos, the governor, in FCT, the minister, to get authority to build such houses or make such grants to build houses. So that's another impediment to housing in these two parts of the country. It appears that the biggest challenge with regard to land rights is the problem of multiple grants from government. One would have thought that with a grant from the government, one has a secure title. Sadly, as a result of inefficiency, absence of commitment, laxity, and maybe fraud, one parcel of land is granted to two or more persons by government departments. And then they get to the land, in the course of building, litigations commence, and the litigations can go on for years, all because the same government department granted the same parcel of land to two or more persons. We find that everywhere. Just recently, I learned that there is fraud going on in some government departments. When a lawyer goes to the government department to make a search, usually the search is computerized. He goes there, they punch the computer. What he sees on the screen, he believes is the proper title of the prospective vendor. However, a fraud can get to the office, convince the official uploads the interest, the name, and particulars of the fraudster on the system, maybe for 1 week or two. The lawyer gets there, makes a search, finds the fraudster's name on the computer, imagines he has title, encourages his client to purchase. And thereafter, the fraudster's data are deleted. The rightful owner's data is on the machine. When dispute arises, the lawyer imagines that he has given his purchaser or his client a good title, only to find out that the fraud had gone on in the government department. And it appears that much still has to be done to ensure that persons of character occupy offices in land offices. There are cases where government officials track the right holder's life, and upon his death, his interest is granted to somebody else. A right of occupancy is not a life estate. It is it's hereditament. So it can be inherited by the heirs of the grantee. That happened in one case, which is cited in the paper here. So much still has to be done in order for us to get proper title to land, courtesy of officials in the land office. Then there is a problem that is peculiar to maybe West Africa or the entire Africa. That is multiple possessory interest. Multiple possessive interest. Now, we have what we call customary tenancy, where many years back, decades, maybe a few centuries back, land owners welcomed strangers to their community, gave them parcel of land to reside on. Then the overlord, or what we call the overlord, the landlord, keeps a reversionary interest. The customary tenant enjoys possession. The third party does not know the distinction between the overlord, may not even know that land is subject of the overlordship or customary tenancy, and the customary tenant. So he approaches the customary overlord, for example, gets title from him. At the time of building, the customary tenant challenges him. Alternatively, the customary tenant sells, the purchaser imagines he has a good title. At the point of sale, the customary overlord comes and challenges his title. And because of, let's say, hard-heartedness, rather than reconcile the two parties and ensure that the purchaser gets a good title, what happens is that litigations ensue. And then this goes on for years. Now, Section 36 of the Land Use Act was thought to have solved this problem. It provides that whoever occupies land at the time the Land Use Act was enacted, and the person was using the land for agricultural purpose, the land occupier should be the occupier and the holder of the right of occupancy. But when the matter came before the Supreme Court in Abioye and Yakubu, the Supreme Court said no, that customary tenancy still exists, and the overlord's title remains. So the problem that existed prior to the Land Use Act still continues. Namely, you get possession and title from a customary tenant, you get possession and title from the customary overlord. Another challenge is demolition of buildings. Section 43 of the Land Use Act empowers governors to demolish buildings where the builder has no title. And the governors have used this a number of times to demolish buildings. The excuse or reason they have is that these buildings do not meet certain conditions. No building permit, the right holder does not, the builder does not have title to build, and so forth. My argument here is that in some parts of the country where demolitions have gone on, government is in search of aesthetics. We have to decide between aesthetics and the need of the poor for shelter. We have to decide which is priority for us. Is it aesthetics or is it basic shelter? That is something that we have to think about. Then there is the problem of revocation of right of occupancy. The current practice is that certificates of occupancy contain conditions. If you have seen a certificate of occupancy, you say the grant is made subject to these conditions. Now, in law, there's a distinction between a condition and a covenant. In a covenant, where there is a breach of a covenant, the tenant or occupier is given opportunity to rectify the breach. If he rectifies the breach, he continues to enjoy his land. If he fails to rectify, then the landlord goes to court to get a court order to get him out. On the other hand, if it's a breach of condition, once the condition is breached, the landowner or the landlord can go into possession and get the tenant out. So, are the conditions in certificates of occupancy conditions or covenants? Remarkably, what we now have as Land Use Act actually evolved from what we have as crown lands, which the colonial masters imposed, not only on Nigeria, but in most other parts of the world where the British Empire extended. So in Kenya, they had something similar to what we have as here as state land, crown land, or Land Use Act. When the matter came before the Privy Council in 1960, in the case of Bashir and Commissioner of Lands, the Privy Council said that even though the document says it is a condition, they should be construed as covenants. Because if they are construed as conditions, they will be too harsh on occupiers and lessees. So we are urging that the conditions in certificate of occupancy should be construed as covenants, so as to give occupiers opportunity to rectify the breach if there's a breach, and then continue to keep their land. That was what happened in a case called Foreign Finance Corporation and LSDPC. Foreign Finance Corporation was a lessee of land. It was in breach of its obligation to pay rent. Just because it failed to pay rents, LSDPC granted the same parcel of land to somebody else who went onto the land, bulldozed the buildings on the land, and took possession. So the issue went before the Supreme Court. And the Supreme Court said that it was wrong for LSDPC to have bulldozed, empowered a third party to bulldoze the buildings on the land, take possession, without giving opportunity to the tenant to remedy the breach. So we are hopeful that even the conditions continue to appear in certificates of occupancy, they should be construed as covenants. And the present practice of government going onto land because the land is not used for the purpose and so on, bulldozing the buildings and on the land and so on, should stop. Government should govern with civility and go through the due process of going to court and getting a court order before forcibly taking possession from people. Another problem we have with certificate of occupancy is that proper investigations are not done before certificates are issued. Anybody who applies for certificate of occupancy is given one once it meets the conditions set out by government. Government on its part does not do anything to investigate title to find out if the person who is applying for a certificate of occupancy actually has title. So we have cases where we have grants without title, grants without interest. And many certificates of occupancy have been struck down for not meeting the basic requirement of proper root of title to found the title. What is more, we have cases where governments grant certificate of occupancy or letters of grant of rights over land without survey plans, without site plans. Now, no matter how beautiful a document is couched and prepared, if the document does not have, the document of title does not have a survey plan or a site plan, that document is valueless, is worthless, because there is no description of the land. If you say, I'm selling 100 by 100 along Mission Road in Lagos, for example, where along Mission Road? Is it at the beginning, midway, or at the end? So, without a survey plan, without site plan, document of title is valueless. And there are a number of grants made without proper certificates of, without proper survey plans. We conclude by looking at the land of the consent provisions. I do not think that Parliament intended that the consent provisions as set out in the Act should be used the way they are being used now. For one thing, many governments are using the consent provisions to make money. That could not have been the intent of the lawmakers. All manner of taxes, all manner of impositions are inserted in the way of attempt to get consent. In Lagos State, for example, without consent, you can't get building permit. And without building permit, you cannot build. It's not the same in Edo State. In Edo State, you can go and get building permit while you are processing your consent or certificate of occupancy and so on. So, because of this, sometimes getting consent, getting building permit goes on for years, even where the purchaser has done everything within his powers, pays all the fees. This is impeding building. That is why we know that certain buildings go on at night. Certain buildings go on only on Saturday and Sunday when government officials are not on patrol. And then because these buildings are rushed, blocks are molded on Saturdays, put on each other on Sunday, the structures are weak and they are collapsing. I do not know whether it is by coincidence that most buildings that have collapsed have been in Lagos State, where there are stringent conditions for obtaining permit and building and consent. I don't know whether it's a coincidence or it's after effect of the stringent measures Lagos State has put in place to ensure that people do not have building permits, do not have consent until they have been mailed. So we have a few recommendations. The consent provisions of the Land Use Act should be attenuated. We feel that the way it is used by many governments is not the intent of this legislature. Local governments should be empowered to have title to land. Indeed, there is no reason why consent should be only at the state capital. There is no reason why consent should not be decentralized up to local government level, even world level, so that it will be speedier for people to obtain consent. And we join Justice Nziako, who said that once a party has done everything that is obligated on him to do to get consent, then he should be deemed to have obtained consent, so that when he's challenged about consent, you should be able to say, I've paid all that you asked me to pay. It is you, it is government that has failed to give me the consent. And so he should be deemed to have gotten a consent so that he can go on and build. And there is absolutely no reason why building permits should be made subject to obtainment of consent. Building permit should stand on its own, while consent is on another pedestal.